Thanks everybody, and thank you to NGFA for the invitation to Doug and I to join you today. We're going to be talking about, and Jess did a very good segue into our discussion, what we're going to focus on today, and this is the OSHA enforcement angle to the quality risk that you all talked about a little while ago. And one of the things, I look around the room and I see a lot of my friends out there, a lot of folks who have seen and heard me speak about managing OSHA inspections before. And we're going to try and shake things up and do it a little bit different today. I think the agenda calls this a mock OSHA inspection. And we're going to do a little bit of that. We're going to do a little bit of instruction, a little bit of, hey, here are some good tips and strategies for how to manage an OSHA inspection. But we're also going to ask for either some volunteers or we're going to volunteer some people to participate with us and act out some of the scenarios that we run into quite often. And we'll do it, sort of Doug and I are both on the same side of helping employers navigate this inspection process these days. But Doug has great perspective from the OSHA side, so he'll put on the black hat, be the bad guy from the agency, and for the most part, I'll represent employers throughout the process of this mock inspection. But before we get into sort of the mock inspection, we wanted to share a little bit of our thoughts about how to effectively manage an inspection, give you some of the tools that maybe we'll put to use in these exercises today. The first thing that I always think about before we talk about any of the phases of an inspection, any actual interaction you're going to have with the agency, and strategies and tips, I try to think about what are our goals? What are we trying to accomplish during the time that OSHA is in my facility, during the time they're reviewing our records, during the time they're visiting with our employees and making decisions about citations? What are our goals for how we're going to manage this inspection? And this will inform a lot of the strategies that we're going to talk about today. And the first thing and the most important thing from my perspective is controlling the flow of information. And that, maybe that sounds like we're trying to sweep things under a rug or hide them behind the big curtain, but it's not about hiding things. It's about controlling the manner in which OSHA sees it, the time that they see it, the volume of what they see when they make requests for training records or programs and procedures, the light in which it is viewed by the agency. And likewise, with interviews with employees, it's which employees they sit down with, in what room, in what environment are they conducting the interviews, and in what role do others in the company have to play to sort of change the quality of that interview before and during the interview. All of those things, likewise, the physical observation of your facility. Where in the facility is OSHA able to go? When do they get to go there? What routes do you take to get there? All of that is about controlling what OSHA sees, when they see it, how they see it, to help cast your workplace in the most positive light. So that's, to me, one of the number one goals of managing an OSHA inspection is controlling that flow of information. And that's a lot of what we're going to be talking about today, is how you interact with that inspector once he arrives and throughout the process to control what he sees, when he sees it, how he sees it, and how he thinks about it when he's looking at it. Another goal that we try to look out for during the management of an inspection is minimizing business disruption. Having an OSHA inspector on site is one of the worst things for productivity at your facility. People run off and hide, they stop doing their work, they are working anxiously, they're working nervously, and it just is not good for productivity. To say nothing of the fact that OSHA is going to start asking for a bunch of documents. So somebody, instead of doing their actual job, is rounding up records for OSHA. They're going to start asking for interviews. So instead of doing their actual job, they're sitting down maybe with a company lawyer or manager to prep for the interview, and then sitting down with OSHA during the interview. So it's a very disruptive process, but there are tools and strategies that you can implement during the inspection to minimize that disruption. And really, what I like to do is combine those two goals. We are going to represent to OSHA that we are trying to minimize their disruption of our workplace so that it gives us control over the flow of information. You want to talk to every employee right now and interview every operator. Well, we can't do that because we're in the middle of loading a rail car. So why don't you come back later this afternoon? We'll bring the guys up to a conference room one at a time and do these interviews. That gives us time to visit with those employees, to prep them for an interview, gives us time to maybe clean up the elevator a little bit, address some low-hanging fruit before those interviews start. So we're using the goal of minimizing business disruption, and OSHA has to honor that and be reasonable in their inspection to implement some of these other goals we're trying to accomplish. Casting the workplace in the best positive light, I've already talked about that. That's really the same thing with the controlling the flow of information. The idea here is to not sort of go down the negative path with OSHA. They're there to find, non-compliance. They're not there to hand out trophies. So, you're not going to go down that path with them of talking about the negative, showing the negative, featuring the negative. You're going to want to cast your programs and your policies and your training and the workplace itself in the most positive light. And then another goal is to identify potential problems early, preferably before OSHA, but even if it's after OSHA, it's quickly and you're going to address it without acknowledging that it's any kind of violation. But through the tools that we're going to talk about today, there are a lot of ways that you can find out, what does OSHA think is problematic here? What are they keying in on during this inspection through your interaction with them during the inspection itself? So I'm going to let Doug talk about some of the inspection rights, and then we'll get into the actual phases of the inspection itself.
We've got it right here. Thank you. Good morning, everybody. Had to dig my black hat back out of the closet. Thought I'd put it away for good. How many of you have been through an OSHA inspection? Personally, wow, every hand went up. That's, well, I guess we're done here. Would you have any OSHA officials in the room? I don't mean to be paranoid, but no government representatives present. Other attorneys? I always like to know if we have other attorneys in the room as well sometimes. No other attorneys? Okay, fantastic. It's the kind of audience I'm looking for. Well, we're going to talk, again, I'm going to try to lend the OSHA perspective on, the psychology of the inspection, the mindset of the compliance officer, issues like that. We'll try to go through that as Eric described and give you some suggestions and some recommendations for how you might make the process less worse. I mean, the process is never pleasant, frankly, for you or the compliance officer, in all honesty. It can be challenging for both parties, but we're going to go through some elements that we think are important for you. Certainly there are still a lot of misunderstandings about the process. I run into people all the time who don't understand what their rights are, and that impacts the way that the inspection progresses. And so those are important things for us to consider. I need to change this, right? So the Act actually says, the Occupational Safety and Health Act states that OSHA has the right to make inspections at reasonable times, in your workplace, reasonable, during regular working hours, typically. Other reasonable times within such reasonable limits in a reasonable manner. Anybody know what reasonable means? I don't think OSHA does necessarily either. I think OSHA believes that when they're ready, it's reasonable, right? So that is a debatable topic and something that legal counsel can certainly guide you on. I will say that in my work experience, reasonable was typically between 8 and 4:30 Monday through Friday. I mean, I was a federal employee, frankly, so. But there are times when imminent danger situations, perhaps, or a fatality investigation where there may be a need to access the site, during non-working hours, and that will be addressed at that time. But for the majority of inspections, whether that be complaint, referral, an accident investigation, or a programmed inspection off of one of OSHA's programmed lists, those will be during normal working hours. And frankly, the OSHA guys, the guys I worked with in the Omaha area office are no more eager to work off shift than anybody else, to be quite honest. So they will tend to stick to those reasonable times. I think limit disruption, Eric mentioned that. Again, this is a subjective concept. OSHA feels that it is their inspection. They're going to do it the way they want to do it. It's going to take as much time as they need to perform the inspection. And quite frankly, they're not worried about disrupting your operation, at least in my experience. And again, I can only speak from my experience. So that's going to be something that we're going to have to consider as well, because I can remember being on an inspection team that was in a facility for 5 months, day after day after day after day, 2 or 3 of us on site for almost the entire duration of the statute of limitations. I mean, we were there digging, and that had to be disruptive. They had a team of people accompanying us every day, and as Eric said, that is extremely disruptive. I'm not sure it was even reasonable, frankly, in retrospect, but it was certainly disruptive. So that's another thing that we may want to consider when we're dealing with OSHA. How long is this going to take? What's your estimate? How disruptive is this going to be? Something we'll have to consider. Next slide. OSHA's inspection rights. The right to inspect workplaces based on probable cause. As you know, the bar for probable cause in administrative law is much lower than the bar for criminal law. So, as far as OSHA is concerned, probable cause really means there's a likelihood that there's a hazard in that workplace. And that could be an imminent danger report. That could be certainly a fatality or catastrophe that has occurred. A complaint, we did a lot of complaint inspections, and a complaint that alleges certain unsafe conditions is considered probable cause for OSHA to make entry into a facility to conduct an inspection. Referrals, when I was with OSHA, we used to get referrals from other government agencies. We would get them from healthcare providers, clinicians who were treating employees from a certain facility, and they might have concerns about that. So we would get referrals from them, and then programmed activities. We would develop, as you know, we would develop local emphasis programs in our jurisdiction to try to gain access to facilities that we were interested in. We believed there were likely hazards in those workplaces. And so as far as OSHA is concerned, that is probable cause, and that will get them into your facility. And all the times that I was asked to get a warrant and justify that to the magistrate, those were upheld. I never had a warrant denied based on the lack of probable cause. So this issue of plain view hazards is really a bit of a conundrum. OSHA considers plain view anything that I can walk to, at least the compliance officers that I worked with. And it's really not the definition of plain view. I think we will elaborate on that. But the plain view issue, as we discussed in the opening conference, is really something that is somewhat gray, and I think we need to pay particular attention to that. Plain view is, OSHA believes that if they are conducting an inspection, whether that be a limited scope, a complaint, or a comprehensive, anything that they see within plain view of the conduct of that inspection is really fair game to expand upon, and that's not really what the statute allows. And so we'll discuss that in more detail. That's important to us to be aware of. There's no advance notice given. Everybody's been through this. They just show up. It's never a good time. I didn't have anybody tell me it was a good time to have me there. Made hundreds of inspections, and no one was ever happy to see me, nor was it a good time. But that's just the way the system works. Other than very rare circumstances, there will be no advance notice given. They just show up and they're ready to start. They have a right to look at your records. They have a right to look at documentation, training records, written programs that pertain to the scope of the inspection, as we will discuss, okay? Right to collect physical evidence. We used to take, when I was an inspector back in the 90s, we carried this huge video camera. Do you remember that? I mean, we would film with literally a shoulder-mounted video camera. Then we progressed to small video cameras, and then, we were taking Polaroid photographs. If you remember those days, are any of you old enough to remember that? Not many of you, it doesn't look like. But, now it's all digital. Everything's digital. It's uploaded to a cloud somewhere. It's very sophisticated. But they will, take physical evidence. They will take measurements, certainly. They will take photographs. They will record interviews, perhaps. That's something that they're desirous of. And they have a right to conduct interviews, and we'll get into much more detail about interviews. Plain view is an area that there's a lot of confusion about, and there's a lot of confusion about interviews. And so hopefully we will clear some of that information up for you. Employees' rights. Since I'm the OSHA guy in today's scenario, thank you. I'm going to be the employee advocate, right? That's what OSHA's job is. They advocate on behalf of the employee. They're not there for the employer. They're there to make sure the employees are being provided a safe workplace. And so employees' rights are of primary concern to the OSHA inspector. You have a right to file a complaint, all right? And if you read the OSHA website at all, if you get any type of OSHA notifications or updates, you see these discrimination issues constantly. I've never seen anything like it. The safety side of it has taken a back seat to discrimination, frankly, it seems like. Everything OSHA puts out is about do not discriminate, do not retaliate. Do not quash an employee's right to file a complaint or, notify about a hazard or an injury, something like that. It is really heavily focused on retaliation and discrimination right now.
The available penalties for the retaliation, the whistleblower actions are much higher than the traditional safety violations, which is a reason why OSHA is putting a lot of resources there.
Yeah, absolutely. It is unlike it was when I was an inspector. And not that we didn't keep that in mind, obviously, but it's very heavily focused on right now. And everybody knows the penalties went up, right? I mean, we talked about that yet? Did you mention that? August 1st? Okay, you're going to talk about that? Because I'm in communication with a lot of my buddies in the OSHA office here in Omaha, and the penalties have gone up, and they are aware of that, right, within the office. That's an important consideration as well. Participation rights. The employer is entitled to an opening conference so that they will understand why OSHA's there, what they intend to do, what the scope of the inspection will be. The employees have a right to participate in that opening conference. If they're part of a bargaining unit, certainly a representative of the bargaining unit will be notified and will be allowed to be present. And in my experience, they typically were interested in being present. Even in the absence of a bargaining unit, they may have an employee representative from a safety committee or something like that that would be permitted to participate in the opening conference. Now, to be quite honest, in most situations, there were no employee representatives present. When I did an opening conference, it was typically just the employer present, but that is within their rights to provide someone to participate in the opening conference. The walkaround, never let the OSHA compliance officer walk around unaccompanied, okay? That's a big mistake. So I have this client, I'm sidetracking slightly, but I have a client who was inspected by OSHA. They had a complaint filed. The compliance officer here in Nebraska went out to the location, went into the office of the facility, notified them, that he was with OSHA, why he was there. The plant manager was on the phone and couldn't be bothered, and so assigned one of his employees to take care of the OSHA guy. You take care of this, I'm busy. And the assigned employee also happened to be the complainant, just coincidentally. And not only did they cover all the complaint items, but they also covered everything else in the facility that he'd thought of since he filed the complaint a few weeks earlier, right? It was a disaster. And what am I trying to say? Horses left the barn or whatever. I'm from the city, so forgive me if that's not the actual expression. But you know what I'm saying? It's too late now. And so accompanying the compliance officer during the walk-around is critical. And the employees have a right to participate in that walk-around as well. Private interviews, employees are interviewed in private, as we will discuss in more detail. The employer representatives may have representation. And as Eric, I'm sure, will say, that is very important. My clients, I recommend that the management officials that are speaking on behalf of the company never get interviewed by themselves. Either there's another management official with them or they have counsel with them or whatever the case might be. Never by themselves. Closing conference. At the end of the inspection activity, there will be a closing conference. That might be face-to-face, that might be over the phone at a later date, but it'll be an opportunity to discuss the apparent violations that OSHA has found. As you know, in every facet of this inspection, it's important to be paying attention and listening and asking questions if you're not sure about something. Opening conference through the closing conference. In my experience, once I would say I'm with OSHA, they would lose their mind. They'd start thinking about, oh my God, how much is this going to cost? My daughter's got dance class tonight. Everything goes nuts, and they don't hear a word I said, And in the closing conference, the same thing. If I told them the penalty amount up front, what the proposed penalties were, they didn't hear another word I said, So you have to focus and pay attention. We won't get into detail about informal settlement conferences today. That would be following the issuance of citations, but you have a resource here that can discuss that in detail with you if you want to know more about that. And then access to inspection records. The employees have a right to see the outcome of that inspection. You'll be required to post those citations, as you know, so that the employees can see that. If you do schedule an informal conference, you have to post that notification as well, so the employees know that you are entering into an informal settlement conference with OSHA. So the employees are They have a right to be apprised of all of those steps throughout the process, okay? All right?
All right, so I'm going to talk about employers' rights, and everybody raised their hand. They've been through one of these. Maybe it didn't feel like you had rights in this process at all, but you do. I think pretty powerful rights. The first thing that Doug talked about was that Section 8A of the OSHA Act that talks about OSHA must be reasonable. In a reasonable manner, I think, is one of the most important phrases in the entire OSHA Act. That is where I derive all of my arguments, all of the things that I do during an inspection to be a pest and a nuisance to the OSHA inspector comes from that phrase, in a reasonable manner. I think that OSHA has to, ask for interviews in a reasonable manner. And when, in a reasonable manner means at a time that is appropriate and fair and not so burdensome to the company. The right number of people, if they're asking to talk to every one of our employees, I don't think that's reasonable in a complaint inspection about a specific location in the facility. Asking for 10 years worth of training records when I think 2 or 3 years of records would be perfectly adequate, especially in the grain industry that has an annual training requirement. Going back multiple years, I don't think is reasonable. So this phrase gives me the opportunity to push back on OSHA in a lot of different ways during the inspection process. Other rights that employers have, and they sort of sometimes all roll up under that Section 8A, but others include this demand an inspection warrant. You have a right to do that. I'm not standing up here telling you that you should do that, but it is there are certain circumstances and times where it is needed, but know that you have the right. Simply having the right gives you some leverage in this inspection process. I mean, to be honest, OSHA's got most of the leverage in this process. They've got subpoena authority, they've got warrant authority, they've got a badge, and they've got a job to do. But the fact that you can demand a warrant gives you a little bit of leverage, and that allows you to negotiate with OSHA. And that's one of the things that we're going to do during this mock inspection exercise is to show how you can use the warrant leverage and the subpoena leverage, because those things, they're not hard for OSHA to get. Right? Doug said he'd never had an application denied, but they take a little bit of effort, and that's something that, frankly, they don't want to do. Right? They got a bunch of inspections they got to knock out. They got to prove to their boss that they're doing their job, and they've got their numbers to hit. And if they've got to go back to the office and write out a subpoena or write out a warrant application and go down to the courthouse, that takes time, it takes burden. They don't really feel like doing it. So if you can say, I'm going to demand a warrant unless we can agree on X, Y, and Z, sometimes that works, sometimes it doesn't, but it's the little bit of leverage that you have. You have a right to hold an opening conference. I think the opening conference is the most important part of the entire inspection, and that's where we're going to do our mock exercise today. That is the last chance you have to stop the inspection before it starts. Maybe OSHA's in the wrong place. Maybe they don't have a right to inspect you based on the inspection program that they think applies, or that you've been inspected in the last 3 years, which should exempt you from certain inspections. Maybe the complaint is totally bogus. It comes from a former employee and has no basis in reality at all. You might be able to stop the inspection before it starts, but you can only do that if you have a thorough and thoughtful opening conference before you consent to the inspection, before he starts walking around your facility. You have a right to access a copy of a complaint. A complaint-based inspection is one of the most common forms of inspections in our industry in particular. OSHA comes out there because a disgruntled employee or just an employee who's concerned makes a phone call or now makes an electronic complaint to OSHA on their website. You have a right to see a copy of that complaint before the inspection starts. And I think that's incredibly important, right? The inspector wants to do everything. We talked about the visit where the elevator manager was too busy to get off the phone. He wants to do a grand tour of your facility and find everything he can find. But the complaint should be his focus. So if you're not looking at the complaint during the opening conference and bargaining with OSHA over the scope of the inspection, you're losing out on a real big opportunity there. So make sure you ask for that, study it, challenge whether it's a legitimate complaint if that's appropriate, or at the very least bargain with OSHA to limit the scope of the inspection appropriately. Right to protect your trade secrets and confidential information. That doesn't mean you won't have to share it with OSHA, but it does mean you can dictate that OSHA doesn't share it with the rest of the world in response to a FOIA request. I take a very, very broad view of confidential business information. Basically everything that is your document. If it's a manufacturer's manual for somebody else's equipment, that's not your confidential information. but pretty much everything else is. So I label everything as confidential information for a couple reasons. The main one being, if there is somebody out there submitting a FOIA request about you, you want to know about it. And by labeling things this way, OSHA is going to call you or send you a letter and say, hey, we got this request. Is this stuff really confidential business information? And you could say, well, who's asking about me? What's the request for? Maybe it's a plaintiff's attorney. Maybe it's one of your competitors. Maybe it's a union who's thinking about an organizing campaign. Maybe it's the media. But by labeling things so that OSHA can't share it with the public until they talk to you about it, you get some notice about who's snooping around your business. You have a right to accompany the co-shows during a walk-around. Very important, Doug mentioned already. You've got a right to participate in supervisory employee interviews. We'll have a whole section on that. Very important process. A right to a closing and a right to challenge citation. That's the last bit. I think everybody knows that. I hope everybody knows that. OSHA is not the last word. They get it wrong a lot. Sort of shockingly often do they get it wrong. And when they issue a citation, that doesn't mean you violated the law. That means that OSHA has alleged that you violated the law. You've got a right to challenge that, and there's a lot of opportunities, short of a full trial, short of paying a lawyer a whole bunch of money, to get that thing righted. You know, you can go into an informal conference, you can continue to negotiate with OSHA even after a notice of contest, well before a hearing, to get to the right outcome when OSHA gets it wrong, which they do quite often. So these are the stages of an inspection, and we're going to do some exercises and ask some questions and do all kinds of fun stuff through each of these stages. An opening conference, the walk-around, employee interviews, and document production, that all happens sort of at the same time. Then a closing conference, then the citations are issued. So we'll start with this mock exercise now. Doug will set up the background facts, and then we'll see if we can get a volunteer or volunteer someone to come join us for
So
this.
everybody can look down right now. So here's the background information for our mock inspection. This is a co-op with an elevator, flat storage, rail loadout, ammonia plant, maintenance shop, you know, the whole works. It's a standard, fairly large-size co-op. They've received a comprehensive inspection back in January of 2014. You know, you go on the OSHA website, you can find out all that inspection history. This facility received an inspection. They had a few violations for 272 issues. Some training violations, some bin entry procedure violations, you know, the usual. Well, I shouldn't say the usual. Man, it doesn't take long to slip back into that OSHA mode, does it? I mean, holy cow. The elevator manager happens to be here today at the conference, which is always the case. You know, the people in authority are never there on site when they show up, we show up.
I actually have an email from a client, a grain elevator client. OSHA has showed up at their facility today. I don't know if their guy is here or not.
Oh, of course. I used to joke when I was the OSHA outreach guy, I would go out and I would speak to groups and I would say, you know, normally you'd be asked to leave your phones off, but, you know, we've got guys out in the area, so I'd recommend leaving your phones on. And not an hour later, some guy stood up and scowled at me and said, I've got to leave. One of your guys is at my plant. And it was totally coincidence as far as he knows, right? I mean, so, you know, so the boss is gone. Right, the boss is gone, and there's an operator on the facility that's now moved up into kind of a supervisory role for the company. The operator put down a leg. The boot pit is waist deep with grain in the middle of loading a shuttle train. So they're busy. You know, they got a lot going on. OSHA receives a complaint, new employee complaint regarding welders and unguarded bandsaw in the maintenance shop. Okay? And the OSHA compliance officer walks into the front office, unannounced. Right? Unannounced. So, do we have any volunteers? Anybody want to participate? I mean, if you have not participated in an opening conference, this would be an opportunity for you to, you know, and you're not going to get any better treatment than you're going to get from me. I assure you that. So, anybody? Don't make Jess do it. He's been through this so many times. He doesn't want to do it. That's right. Yeah, come on up, please. Come on up. Fantastic. Nice to meet you. Where are you from? Oh, Council Bluffs. Very good. Very good. Let's talk a little bit about the opening conference. The COSHO, the acronym COSHO, Compliance, Safety, and Health Officer, you see that referred to a lot, and I'll probably use a number of acronyms. I apologize for that. They arrive and they typically display their credentials, right? They carry credentials. That is an integral part of this process. I can't tell you how many times when I was a team leader, I had compliance officers call me and say, I'm sorry, I'm out in western Nebraska. I left my credentials at home. What do I do? There's nothing more frustrating as a team leader than, you know, because without those credentials, How do we proceed? So credentials are important. You're not allowed to copy them. The OSHA folks will not allow you to copy them, but you can certainly write down information. When my clients call me, and the first thing I ask them is, well, who's the compliance officer? Because I know all the compliance officers, and that makes a difference in how the inspection is going to go. Quite honestly, here in Nebraska, I don't know. I don't remember his name. Well, write his name down. You know, that's important information to have available, okay? And if you're concerned about his identity, you're certainly entitled to call the office and verify that, you know, Doug Fletcher is here. Is he supposed to be here? You know, why wouldn't you make such a, you know, confirmatory, is that a word? Phone call, right?
It is today.
I mean, yeah, it is today. Thank you, Eric. I appreciate it. The opening conference begins. Employee reps may participate. So we'll make notification that if you do have an employee representative, they are allowed to participate in the opening conference. The COSHA is going to explain the purpose of the inspection, you know, why I'm there, under what authority I'm there, what we intend to do, what the scope of the inspection will be. We'll discuss scope and duration. It could be wall-to-wall, which is a comprehensive inspection. It could be a limited scope based on a complaint or an accident or a referral, perhaps. It could be under a national or local emphasis program. You know, in Nebraska, we have a grain local emphasis program. I think other states do as well, so Nebraska does. At that point, I'll put in a request for some documentation. I'm interested in doing the walk-around, okay? COSHOs don't like reviewing documentation. They like walking around. So they want to get started with the walk-around. You know, hey, get me this, 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 and this. Let's go do the walk-around, okay? They'd like to get started. And then we'll have to resolve any warrant issues. Now, in my experience, and Eric can, you know, clarify this, but there is no requirement for OSHA to read you your rights. There is no Miranda requirement in administrative law. If you don't know your rights, I'm sorry, okay? You know, that's why we're here, right? As a compliance officer, I'm not going to tell you your rights, okay? I might, frankly, this is going to sound bad, but I might not even know what your rights are, truthfully. If I'm a new compliance officer, I may not know your rights any better than you do. I was just sent here to make an inspection, so let's get started, right? So it's important. So the warrant issue is something that you will have to resolve internally.
Yeah. Talk about that a little.
You want to talk about it? Okay.
So just do this very quickly on the warrant issue. You have a right to a warrant, the same as you do. The Fourth Amendment of the U.S. Constitution applies just the same in your workplace as it does in your home, your vehicle, and all these things. So you have a right to demand an inspection warrant, or conversely, OSHA cannot proceed to inspect your workplace without a warrant or your consent. And 99.9% of OSHA inspections proceed with consent, but there is this warrant issue hanging over, you know, the backdrop of every inspection. And there are risks and there are benefits to doing this, and the risk is you're going to piss them off, right? They don't like for you to test their authority. They don't like to do paperwork. They don't like to be slowed down. So if you demand a warrant, it's going to throw up a red flag that says I'm hiding something and I'm just making the COSHA work harder. And they don't like it, and they will tell you. You ever ask a compliance officer or anybody at OSHA, we do the same inspection whether you ask for a warrant or not. I don't really think that's true. I think they're going to look a little bit harder. They're going to turn over a few more stones. They're going to be a little bit nastier. There are things that they might see and say, hey, here's some advice, go fix that. If you demand a warrant instead of advice, that's going to be a citation. So there is a risk that you're going to be looked at with a bit more scrutiny and retaliated against for exercising that right. But there are benefits as well. There is a restraint on time. If you demand a warrant, you're probably not going to see OSHA for 3 or 4 days or even a week or 2 weeks before they come back with the warrant to do the inspection, and that gives you time to do whatever it is that you need to do to get ready for that inspection. And the reality is OSHA can cite you for a condition that existed that day, even if they weren't in your plant to see it, but it's a little bit harder to learn about it if they are turned away and they have to come back. So if there's something going on at your plant, I don't know what it is, what it could be, but that you just cannot have OSHA see that day, and maybe demanding a warrant is appropriate in those circumstances. The other where I think it is mostly appropriate is if there is a person within your company who you want to participate in the inspection. Your corporate safety manager, the elevator manager who's here at the conference today instead of at the elevator, your general counsel, your outside counsel, and that person is not present when OSHA shows up, and you say, he can be here tomorrow morning, or he can be here later this afternoon, or he can't, he's on vacation, he won't be back till next week. Can you come back later? OSHA's going to say, I'll wait an hour. And you say, well, I need you to wait 4 hours, or I'm going to demand a warrant. And sometimes that plays out that they say, okay, we'll come back in 4 hours. Other times they say, well, you've got a right to demand a warrant, go ahead. And either way, the inspection's not going to proceed until my representative is there. But sometimes you've got to ask for a warrant to get that. So my tip generally, though, is I don't like to demand a warrant unless I absolutely have to, but I don't mind talking about it during the opening conference and using it, as I said, as some leverage to narrow the scope of the inspection, to narrow the scope of interviews, to do something that I want to control about the scope of the inspection. And we'll talk about some tips real quick, and then we'll play this out with Zach. So insist on an opening conference. As Doug said, Kosho walks in, he wants to get out into the elevator. Yeah, question?
I guess about the warrants, we haven't ever asked for one. But I'm not sure I know what an official warrant actually looks like.
Mm.
If we did, and they came back with something written, does it have to be, for example, does it have to be signed by a judge?
Yeah.
And is there a specific format that it looks like? Does it vary in different states?
Yeah.
Does it vary in different areas?
Yeah, so the question, if you didn't hear the question, is, we've never asked for a warrant, but if we did, I'm not even sure we'd know what one looked like. They could come back in with a baseball card and say, hey, this is a warrant. How do we know it's real? There's a difference between a subpoena and a warrant. A subpoena can issue straight from Doug's desk when he was at OSHA. They write out their own subpoenas for interviews and documents and physical evidence. It has to be enforced at a court, but it's issued by OSHA directly, and that can look like anything, whatever form that area office or that region uses. A warrant is issued by a court, and it is going to look like an official court document. It's going to have a caption. It's going to have a judge's signature, probably a magistrate judge, to be honest, but it's going to, they more or less will look pretty consistent across the country. They're going into federal court and applying for an administrative warrant, and it's going to be, it's not a one-pager. There's a document behind it. They've got to file an affidavit supporting why the inspection is appropriate, and ultimately it will be signed by a judge, and it will define the scope of the inspection. These things are done ex parte, which means they're done without you present. The employer has no participation in that process. So OSHA gets to really influence the scope of the inspection that he's asking for from the judge. Hopefully the judge is doing his job and limiting it appropriately, but that's what it'll look like. They'll probably bring a copy. It may not be a raised seal, but there'll be a seal on it, official government seal. There is an original somewhere that has a raised version. They probably won't be bringing that. Maybe they will. So some quick tips so pay attention, Zach. You're going to have to deal with all this stuff here. Insist on the opening conference so OSHA doesn't just blast in the door and walk right out to the elevator and start walking around taking pictures. You want them to sit down in this conference room, and frankly, I want my opening conferences to last as long as possible, because the reason why OSHA wants to get right out into the field is because they know in the back everybody's running around. Hey, OSHA's here, put on your hard hat, clean up the elevator, let's get, do things the right way. Well, that's why I want a long opening conference, because those things are happening, and I've got no problem with those things happening. Let's go out, check out the low-hanging fruit, let's get our ship in order. So insist on an opening conference, ask lots of questions. You can ask the guy to wait to start the opening conference until you can get your representative present, get folks on the phone if they need to, but let's take our time with the opening. Select a location in advance. When you leave here today, you can go back to your facility and say, if OSHA shows up tomorrow, where do I want the opening conference to take place? I don't want it to take place in a training room that has all sorts of binders up on the shelves and maybe our incident data up on a chalkboard and incident reports laying out on a conference table. I want it to be in a sanitized room that has no information that might interest the compliance officer. And it's somewhere that you don't have to walk through the elevator to get to this conference room, so he's not already looking around for violations before the opening starts. Front office, maybe even, if you've got sort of a loadout office that's not even at the elevator at all, great, let's do a location like that. And if he's not volunteering or if he's not providing enough detail, all right, we're running low on time, so we'll skip right to the meat of it. Ask lots of questions about scope, negotiate about the scope. If they're there on a complaint, that ought to be their focus. push back and keep them focused on that, and then explain your protocols. You know, he's got the leverage, but you're going to at least try and stake out a position that this is how this inspection is going to go. If you want documents, make your requests in writing and give them to this particular person. If you want interviews, tell me and we'll organize them, we'll coordinate them, we'll bring the guys up front to the office to conduct those interviews when they're available. And then those are the main gist of it. So why don't we jump in and do this mock opening conference. And so I'm not present. I'm the lawyer. I'm in Washington, D.C. So Zach's on his own here, and he's got the compliance officer walks in the door.
All right, we're going to go ahead and just I just drove across the state. I'm tired. I'm angry, sweaty. My per diem's terrible. So I show up at the facility. Usually the first thing I'm going to do is go right to the office if I can identify it, and walk right in the door, try to identify myself to whoever might be there. So I'm coming in the door, and first thing I'm going to say is, hey, and it's not going to be Zach sitting there. It might be somebody else sitting there. It might be a reception person if that is present in your facility. Typically, we would go through a reception person at the front office. And, you know, my name is Doug Fletcher. I'm with OSHA. I need to speak to whoever's in charge.
How you doing? I'm Zach Wilson.
Hey, Zach.
Would you like to come into the conference room and have a seat?
Yeah, man. I was sent out from the Omaha area office to make an inspection today. And, yeah, if we have a place we can sit down and talk, that'd be terrific.
Come on in here. What is the...
Very good.
What's the scope of your, or what's the reason that brought you?
Well, let me show you my credentials first.
Oh, yeah.
Actually, I don't have any credentials any longer, so we're going to pretend I carry credentials.
Okay.
And
Those look fake to me.
yeah, that's right. Denied. Yeah, I don't blame you. I wouldn't let him in either, frankly. Well, that's another discussion altogether. We'll sit down in your conference room. I don't know if we can work from this. Are these live?
These mics work.
We can work from these. So, so as I mentioned, you know, I'm with OSHA. We got a complaint. We received a complaint from one of your employees. It's alleging that there's some serious safety conditions here on site, and I've been sent out to take a look at those. The scope of the inspection is going to be comprehensive. I'm going to have to take a look at everything, frankly. So we'll go through the elevator. We have to look at flat storage, warehouse, your ammonia plant, whatever else you have on site. The complaint itself actually alleges issues in the maintenance shop. So, but I'd like to see the whole facility.
Well, if it's just the maintenance shop, let's try to keep it to that. If that's the scope of your.
Well, you know, we have a local emphasis program here in Nebraska, the grain emphasis program that mandates if I'm on site, I have to do if you haven't had an inspection within the last, I'm not going to say that, but if you haven't had an inspection within the last 36 months, then it needs to be comprehensive. Does anybody remember? Yeah, absolutely.
So
Right on.
2016.
Right on. They had a safety inspection in January of 2014, which is within the 36-month period. So.
Well, we had one in 2014, so.
Exactly.
Let's try to keep it to the.
Oh
scope.
yeah. Oh, I kind of forgot about that. Thanks. Well, then we'll just limit it to the complaint items. Okay. We'll just keep it to the complaint items. Got a copy of the complaint right here. The location is the maintenance shop. There were 2 items that were identified by your employee. You've got a Lincoln Electric welder. The employee's being shocked when he's welding. And you got a Bailey vertical bandsaw with no guards on the exposed blade. There's no shroud around the top of the blade. Incredible hazard. He's terrified. Any questions about any of those issues?
Can I get a copy, please?
I'm sorry?
Can I get that copy?
Oh, yeah, okay, you can have a copy.
Thank you.
Excellent. You got to request a copy, right? I mean, in my opinion, get a copy of the complaint and then throw him out if that's what's going to happen, but get a copy of the complaint first. Absolutely, right? I mean, I'd like to know what those issues are. So here's what's going to happen. I'm going to do a walk around of your facility. We'll limit it to the maintenance shop as you requested. I think that's reasonable. I'll probably take some photographs, speak to some employee representatives. You guys aren't union by any chance, are you?
No, we're not.
Okay. Do you have an employee representative that's going to want to participate in this?
Let me check. He's not here right now.
Okay.
Let me give him a call.
Okay. Sure. Well, I'd like to get started, frankly. We'll go ahead and do the walk, but I'm going to need to see your 300 logs, about 3 years of 300 logs plus the current year. If you can get copies of those for me. Probably need to see a lot of your safety programs. If you got a safety manual or something, it might be easier just to,
Well,
give me your safety manual.
You guys should have copies of that since you were just here a couple years ago.
Oh, wow. That's absolutely right. And we probably have some of that stuff. I'll have to check the old case file. Wow, that was excellent.
Okay, so let's well, if you're here for these two specific issues, that's all we really need to focus on. I mean, if you were here
Okay.
just a couple years ago, you have the knowledge that all my guys are up to date as of what you've seen, and
Very good. That's excellent observation, man. I probably will do some interviews. I'll need to speak with you. So are you in charge today?
I am acting.
Okay.
The superintendent is at a conference in Omaha.
I got you. Okay, so you're the boss, basically?
Appointed for right now, yeah.
Okay,
So-
very good. As I said, I'll do some interviews, probably have to speak with you and perhaps any of the employees that might be out in the maintenance shop. If you got a maintenance guy out there, we'll speak to him.
Yeah, right now, let me take a second to call the superintendent and see if I can get a hold of him.
Okay,
See if we can get him out here, just so he can be informed on what's really going on, and I can also let him know the scope.
fantastic. Okay, well, I got somewhere to be later, so we need to keep this moving along, so.
I mean, I can go as fast as I can go.
All right.
And so.
Okay.
Yeah, good.
Excellent, man. So, when I was an inspector, if you don't ask, you're not going to get, right? And so there were many occasions where the facility manager or the plant manager or the person in charge was not available, and, we would push to get going because I want to get out in the facility, and they would just, set me aside somewhere. And then, as Eric mentioned, yeah, don't stick me in your training room with all of your records. Put me somewhere that's, fairly safe, and then take care of your business. Make your phone calls, whatever you need to do. And if it's going to take more than an hour, then just simply tell them that. Doug, the plant manager, cannot be back until this afternoon. Can we wait until then? Or he won't be back until tomorrow, and we're interested in complying, and he'll be back tomorrow. And if we could do this tomorrow, that would be, much better. And the compliance officer simply calls his boss and asks. And there were many times when I was told, yeah, just spend the night and do it tomorrow.
One of the best things that I think Zach did there was to start to engage in the conversation, get a copy of the complaint, understand what was going on in the inspection before saying, hey, let me go check with my boss and see if he can get out here. So now we're armed with the information about the inspection, and we get to say, hey, let's wait a little bit and see if my representative can actually get out here. So I really like that. I think we've got to take our break now.
Excellent, man.
I'll be the OSHA.
All right, I think right when we were running out to the break, I saw a bunch of hands up, and I know we addressed a lot of questions during the break, but before we move away from the opening conference, does anybody have any questions about that that we can address before we move on to the next subject? Yes, ma'am. Yeah, so that's a great question. There is actually, that I would expect that you will deal with in any inspection at a grain elevator, only one document, one type of document that has any kind of deadline at all, and that is your injury and illness record-keeping records, your 300 log, 300A, 301 incident reports. You have to produce within, I think, 4 business hours of the request. And OSHA's generally pretty lenient on that. Often they'll give you a deadline of, hey, get me this by tomorrow. But if there's no deadline expressed by the compliance officer, you've got 4 business hours to produce the injury and illness records. Everything else, there's no deadline at all. They might give you one. They make their request in writing and say, hey, I want this by tomorrow morning. And that's nice that they want it by tomorrow morning, but there's no requirement to give it to them at any particular time. Employee exposure records and medical records, there's a different issue, but you probably won't have to deal with that. For training records, for bin entry permits, for your safety programs and policies, there is no deadline, there's no time limit. The longer it takes, the more they think that you're making it up, the more they think you're fabricating it, changing it. So you don't want to wait too long, but I think you want to make this a careful and thoughtful process. And what I usually say is, give me the request in writing, and we'll get it back to you, as soon as we're able to evaluate it for confidential business information, for privilege, and make sure we're giving you what you're really asking for. And usually that's within 2 or 3 days. And we'll email it to you, get the guy's card, get the inspector's card, you email it to him, send it to him by hard copy, or if he's coming back for more inspection activities, hey, we'll have it waiting for you when you come back next time. That's generally how I handle that. In fact, we are going to talk a little bit about document production here as well. But this is, really an opening conference issue. Is one of the things I talked about is setting the ground rules for the inspection. I like to do that during the opening conference. That's when I say, hey, listen, I imagine you're going to have an interest in seeing some of our records during the inspection. That's fine. Whatever you need, we'll take care of you. Just, if you don't mind, please put the request in writing and give it to me or give it to John. I like to have a single person who is, in charge of the document production. This one person may not know where every record is, but if we can sort of control that process, it's easier to manage. So I put one person in charge and say, put all the requests in writing, give them to John. We do the same thing for interviews as well. In terms of documents, I also suggest that we don't create new documents. OSHA will often ask for things like, hey, give me a list of all the guys who are, a list of all the guys who work on this piece of equipment. Well, if you don't have a list, if it doesn't exist that, these 4 people are qualified to operate this machine, your answer can be, we don't have that there's no record that has that information. Or, if they look for, you've had an incident and they ask for an incident report and you didn't create one, in most circumstances you're not required to create one. So if they ask for an incident report, you're not obligated to go create one to respond to their document request. We don't have a record that responds to what you're looking for. You want to be careful about that type of response, because if they ask for a training record, for example, and you are required to have one, you don't want to answer that you don't have one. You might just sort of dodge that question throughout the inspection and deal with it a number of different ways. But you don't have to create a document where one does not exist. Don't volunteer information. We've talked about there may be strategic reasons sometimes where you give OSHA something that they didn't ask for, but that's extremely rare. The ordinary course, the smarter course, I think, is to wait for the request, really parse the request, and give them only what they've asked for. One of the biggest things here is that, we sort of skipped over this, voluntary versus subpoena. Most of the document requests during an inspection are voluntary until you've upset the inspector so much that he runs off and gets a subpoena. With a subpoena, you've got to be really careful, because if you don't produce everything that is responsive to that subpoena, you might be limiting your ability to introduce a new document later. If you've not responded to a subpoena, which is a mandatory and compulsory and really court judicial related document, you may waive the right to use other related documents later. For voluntary requests, there's no such limitation. So if the guy says, I want 5 years worth of training records, and I say, well, I think that's too much, here's 2 years worth, let me know if you feel like you need anything more. 9 times out of 10, I get no follow-up request. But then I get a citation that has something to do with training for an employee who was trained on the topic 3 years ago, not 2 years ago. And I can come back in later and say, oh, here's John's training record from 3 years ago. And they'll say, well, why didn't you give me that during the inspection? Sorry, I gave you 2 years worth. This was just a slightly older record. There are no limits there. You've not waived anything. So that's why I like to keep things in the voluntary mode rather than the subpoena mode. But if you do end up with a subpoena, sometimes that happens. You've just got to be a little bit more careful about, giving a more exhaustive response than you do in a voluntary response. I think that's pretty much it for document production. The other thing that we like to do, or that I really like for you to do as your lawyer, is to keep really good track of what you're producing to OSHA. It's very challenging to defend against citations. When I walk in the door, 6 months later, and I say, all right, well, they cited you for inadequate training. Can I see the training records you produced to OSHA? Oh, well, I guess I could recreate that set. Here's what I think I gave them. You're in a tough position in that regard. So I would say make a duplicate set of everything you give to OSHA and keep track of it. Here's an example of a log that I use to track when we receive documents, what exactly they asked for, what we produced, whether we labeled it as confidential business information. I also like to put a unique identifying number on each document, and that helps in the litigation process down the road. So you want to make sure that it's something to consider doing. I like to do that. All right, you want to do a little just sort of show of hands type of thing, or ask some people in the audience about a mock document production?
As far as what we're asking for?
Yeah. You can sort of ask how people might respond to that.
Well, let's go back to our scenario. We're doing a complaint in the maintenance shop. We've got concerns about the welder, and we've got concerns about guarding on a bandsaw. As part of every OSHA inspection, we were instructed by policy to request copies of or at least an opportunity to view your hazard communication program, your chemical safety program, and as we all know, there have been some changes to that of late, and your lockout tagout program. Lockout tagout, of course, would be germane to the use of that saw. So I would ask perhaps to see your specific procedures that pertain to that saw. Hazard communication program, I just want to verify that you do have, a method for labeling, data sheet maintenance, training, that type of thing. But I mean, if I'm in your facility, one thing that I found that was common was when I would ask for a safety program, I need to look at your lockout tagout program, I would be given the safety manual, right, that has everything in it. A lot of programs that I didn't ask for, but now I have them in my possession, and I can, if I'm in the conference room, I'm flipping through them, and all of a sudden I realize, ooh, there's a problem here, oh, this is not good. Oh, I mean, I think Eric commented on don't provide anything that's not requested unless it supports the position that you're trying to make as far as your diligence, with your program, but provide what you're being asked for rather than just volumes of information that OSHA may, at their discretion be able to pick and choose from. I don't think that's necessarily a good idea. I might also ask for your emergency action plan if I'm on site, but if that doesn't pertain to the scope of the inspection as we established it in that opening conference, you may want to question, what my need for that is, or again, you may want to check with counsel to see if it's something that you should turn over, but it would be limited to those types of things that would be specific to that inspection, right? We're not doing a wall-to-wall under these circumstances. We're doing a limited scope inspection, and the documentation that I'm going to request should pertain to, those issues. So hazard communication as a matter of policy will always be requested. The 300 logs, Zach, excellent comment. Those are probably on record in the office if they were asked for during the previous inspection, so all I might need would be anything subsequent to that last inspection. Very good catch, and probably these other programs as well. If they did a comprehensive, those are probably on record in the office, in the case file, so that was an excellent observation. What else might be request document-wise? If you have a saws, one of the things that OSHA is always interested in is manuals. If you have a manual for that saw, are you training per the instructions of that manual? So I might request the operator's manual from that saw. I might request the operator's manual, or I might, on that welder, for example, if I walk into the welder's got damaged, welding leads, I can see copper I can see, the tap changes are uncovered. I can see a lot of things that are wrong with the welder. I might ask you for maintenance records. I might ask you for maintenance requests. Has somebody put in a request to have this fixed and we've just kind of sat on it for a while? Or again, the operator's manuals, things like that. Your training will likely be based on information from those manuals. All right, so that would probably be something that we would ask for. I asked for your bin entry permits. What do you say to that? Well, absolutely not. Again, that's not part of the scope of this inspection as we've determined it during that opening conference. So when I start to wander a little bit, which I will in all likelihood, we need to just kind of rein back, focus, Doug. You're getting off track here a little bit.
You come in to review the welder and whatever.
Sure.
And you ask for the emergency action plan. And we can tell you, really, does that have anything to do with this? What if, when you come into our facility, the first thing we're going to do is we're going to go over the emergency action plan with you. We're going
Absolutely.
to tell you, this is what we're going to do to get out of here, this is where we're going, so that you're aware. Does that open the door for you to ask for that?
Yeah, the attorney's nodding yes, and I would say, though, that as part of an opening conference, the question was if during the opening conference you provide me information about your emergency action plan, because I'm a visitor on your site, right? And so you may have a policy that any visitor on site, whether that be a contractor or government representative, you go through some type of a contractor orientation and you discuss your emergency action plan and those types of issues. Does that open the door then for me to pursue that further? I honestly don't know the answer to that. What do you think?
So, I mean, my thought is if you put the document in front of the inspector and at the top of the list it says, here are the 3 people you contact in the case of an emergency, and one of those people doesn't work at the company anymore, and that's obvious, or there's a phone number listed and it's the wrong phone number, the inspector's looking at it, and if he knows that there's a violation there, I mean, that is sort of the classic plain view
Well,
issue.
That's a good point.
I'm not saying we're gonna give him the document.
So, right.
We're just verbally telling him, in the event of a tornado, we're gonna go here,
Mhm.
you're gonna go with us. In the event of a fire, we're going to evacuate, you're gonna go with us. Does just that verbal,
So I mean, I like that approach a lot better, and that was, we're not going to share a document with them. We're just going to review verbally what we do in the case of certain different types of emergencies. I like that approach a lot better, and I would push back as your attorney if they tried to expand the inspection to say we're now going to look at emergency action plan issues because of that discussion. I'm going to say, look, the fact of simply being aware that there is an emergency action plan, that's not what plain view means. Plain view means I am aware that there is a probability of a violation related to this thing that allows me to expand the scope of the inspection. And by simply reviewing where our muster station is, that could in no way introduce any probability of a violation with our action plan, and we're not going to open that up to you right now. And then maybe you've got a fight on your hands and you've got to balance. I think we've got a great emergency action plan. I'm not afraid to share this with OSHA. I'd push back, but if it looked like it was going to create too big of a dust storm, I might say, all right, here's our emergency action plan. You balance those. You also need to think about it from the perspective of, do I think there are any holes in this plan? Am I concerned about the plan? And if you're concerned about it for some reason, I fight a lot harder to not share it with them. If you're confident in the plan, if it's been vetted by an auditor or by OSHA in a recent inspection, then I say, fine, yeah, here's a copy of the plan. You balance it.
That's a great comment. Interesting. I would say, though, that the OSHA inspector should be treated very similarly to any other visitor to your site.
Yeah.
They would be required to wear the same PPE that you would require in any location in your facility. They can't go into permit-required confined spaces without, they wouldn't. They shouldn't. They certainly wouldn't be permitted to do that by their team leader. They wouldn't be encouraged to do that, but they will have the same limitations that anybody else. You can't go into permit-required confined spaces. You're not in fall, you're not exposed to fall hazards. And frankly, most compliance officers don't want to put themselves in those situations. They're instructed not to expose themselves to hazards. So I would treat them the same way as any other visitor or contractor on site.
So if every visitor or contractor that comes to our location signs in or has a checklist that they sign off saying, I acknowledge I won't spit gum in the top of your bin, and the OSHA person says, you know what, I can't sign anything by law, then you can't go on the plane.
Well, I think for the most part, OSHA compliance officers don't sign anything that's presented by the company. I think that typically sign-in logs that are used to account for people in an emergency, I would always sign into. I didn't have any objection to that, indicating that I was on site so that I could be accounted for in the event that was necessary. But to acknowledge that I will not do certain things, I would have to get permission typically from a team leader or someone in order to sign a document like that. But then, of course, if they're refusing to sign that and you consider that a grounds for a denial of entry, by all means you could do that. I don't know that I would.
Because they don't do it.
Yeah.
They wouldn't let you go in there because you don't do it.
Yeah, and they're notorious gum spitters. So no, I agree.
Our rules are no candy, no
Right,
pins,
right. Well, and maybe no jewelry, I see a lot of hoodies with dangly strings that are very, bad ideas around shafts and things.
employees and our visitors to that level. It's realistic to hold an OSHA inspector to that same level, correct? Why should you be any different?
Yeah, I would certainly inform them of those requirements. At some point he or she will make that decision whether or not they, We'll comply with those, and if that's grounds for denial, that's certainly your right to do that.
Yeah, my view is the closer the connection to safety, the more likely I would enforce the policy for them. If it's about PPE, no smoking, I think that's something where I would definitely put my foot down. Because I think it shows this is how seriously we take our safety program. You don't have, we require, flame retardant clothing to go into
Right.
this location, and you don't have it with you today, come back when you do.
Most
I don't have
definitely.
any
I
problem
would
enforcing
absolutely
that.
agree with that.
Dusty environments, there's no cameras allowed.
Right,
Yep.
yeah, and you have intrinsically safe equipment, which they don't. That's expensive. Now maybe under the new penalty structure, we'll be able to get it. But, prior, we didn't have intrinsically safe equipment when I was an inspector, and so you didn't photograph in the elevator, or you'd stand way out in the parking lot and use a zoom lens or something, or have the employer go in there and take a photograph of it. But yeah, so those are excellent comments. I totally agree with that. Yeah, they're no different, and they need to comply with those same safety requirements. Let's talk a little bit about the walk-around portion of the inspection. We've discussed this. You still out there, Zach, or did Zach call it a day? Okay, man. So the walk-around portion, which is the meat of the inspection for the OSHA inspector, right? This is the part that I am interested in. All the other documentation stuff is secondary, frankly, all right? We've established the scope, so you're going to get me to this maintenance shop without giving me a tour. I know you're proud of your facility.
Next slide. Yeah. There you
Oh, I'm sorry.
go. You got it. Thank you.
Oh, thank you, guys. I've got a lot to deal with up here. We've established the scope, and somehow you're going to get me to that maintenance shop without exposing me to the rest of your facility, right? We discussed this plain view. OSHA is obligated, that compliance officer is obligated to address any plain view hazards that they might observe while they're on your premises, and so we don't want to give them that opportunity. And so we're going to take a route to that maintenance shop, and I'll be honest with you, I walked around a lot of buildings to go in the back door of a lot of buildings, willingly, willingly. I had a facility here in Omaha where I was accompanied through the facility because there was no other way to get back into the facility by two incredibly large guys. And I was trying to, peek around them, but there was no seeing anything else. They were, side by side. And I don't make these stories up because you cannot make this stuff up. I had a guy ask me if he could put a hood over my head to get me out into the facility. I don't make this, and I've been through fraternity initiation. I don't have any more bags on my head. We do not do that. But again, you don't want to give them an opportunity to see parts of your facility that are not germane to the inspection scope. So you figure out a route to get them there that will minimize that potential, right?
Just one.
Please,
a
yeah, go right ahead.
similar story like that. We had OSHA show up on a complaint inspection about forklifts. They said, I think that there was a backup alarm or something like that wasn't working, and that was the scope of the inspection. We negotiated. They agreed to that. So when it came time to do the walk-around, we asked him to step back out into the parking lot, and we brought the forklift out of our shop out to the parking lot and let him physically inspect that forklift in the parking lot, so he didn't see one thing within our building. So there's a lot of creative ways to make sure that once you've got agreement on the scope of the inspection, you do everything: your documents, your interviews, your physical observations. You do what you can to limit what they see because of this plain view opportunity to expand.
That's a fantastic. And as a compliance officer, I acknowledge the. That's fantastic. I'd probably be, good job. I'll give you credit where credit is due, certainly. As again, we're going to take photographs, okay? If the OSHA guy pulls out a camera and starts to take a photograph, what's he doing? He's documenting a violation, right? That's why I'm taking a photograph. Or I may be seeing something that I'm not familiar with and I need to bring it back to the shop and have someone else look at it. It may not be my expertise, not in my wheelhouse, but if I'm taking a picture, it's because I believe there's a violation, and I'm going to use that to support my violation. So I think it's practical for you to take a picture of what I'm taking a picture of. So in your OSHA inspection kit, your checklist, you're going to have a camera perhaps, or everybody's phone now is equipped to take pictures, however you want to do that. But it's probably not a bad idea to have pictures of what I'm taking pictures of so that when you call Eric and say, Eric, we've had an OSHA guy in our shop and I need some help, he has some idea what it is the OSHA guy was focusing on. Because otherwise he's flying blind if you don't have any notes or any photographs of what OSHA was fixated on. He's really waiting for the citations to be able to do anything. So I think side-by-side photographs, industrial hygiene, you have the opportunity to do side-by-side monitoring. That's less common because that's kind of costly, but it's not always out of the question to do side-by-side monitoring if that's necessary. One of the things that I'm going to do, I'm going to take Zach back out into the maintenance shop, and I'm going to say, hey, Zach, I see your welder's, in pretty bad repair here, buddy. As part of this, I'm going to ask, who uses this thing? You use this thing, Zach? You ever use this welder? That's a good answer. Okay, but I'm going to need to establish whether or not, the welder is being used, how frequently it's being used, when it was last used, and I'm going to do that just through, basic conversation with the guys in that, either your maintenance guys or somebody else in the facility that might be available for me to question, right? Can you do some welding for me? I'd kind of like to see if you do get shocked. Would you mind firing this thing up and let's take a run at it? And absolutely not. We don't simulate work for OSHA, right? Hey, I need you to bend some metal. I need you to weld something. I need you to go over there and cut something with that obviously hazardous bandsaw. OSHA should never request that, and they should never request you to do work that isn't on the schedule. And they do from time to time, particularly for industrial hygiene purposes, right? We used to ask all the time, hexchrome's a huge deal, right? Stainless steel, hexavalent chromium. Do you have any work on stainless steel? No, we don't do it very often. Well, could you save a bunch up and then call me and I'll come back and sample that? And you're basically creating an unrealistic exposure so that I can sample you and issue you a citation. So we don't do that. If there's nothing to be welded, we're certainly not going to expose an employee to something that might be hazardous, and we're not going to create work that was otherwise not on the agenda, okay? In fact, in the construction world, they cease work. They don't cut concrete for months after you show up for the silica inspection, We just don't have any more to do, Doug. What a coincidence. That was pretty common, but how long has the welder been in this condition? I'm interested in the duration of that hazard. Why is it in this condition? If you're a management official, if you're an employee, the why isn't as important to me, but if you're a management representative, the why becomes pretty critical. Why hasn't this been fixed? Why is it in this condition? And those are questions and this is all informal as we're standing around in the shop, right? So I've looked at your welder, I've looked at your bandsaw. Of course, I noticed across the shop, oh man, a pedestal grinder. That is the lowest hanging fruit that OSHA can possibly be attracted to. And I'm going to walk over there now and take a look at the pedestal grinder, right? Would you permit me to do that? I can't, if it's right next to me, we may be stuck with that. But if it's across the shop, I can't see from where I'm standing here that it's out of adjustment. I can't tell whether that work rest is an eighth or a quarter or inch from the wheel from here. And so I think, the plain view issue becomes important when I can see you have a grinder, but I can't see that there's a hazard there. And so for me to go over there and now investigate that, evaluate that, would be expanding the scope of the inspection beyond what we'd agreed to.
So that would be, to me, sort of the classic example where you say, all right, you want to go look at that pedestal grinder. I don't think that's part of the scope of this inspection. Let's go back to the conference room and have this conversation again, because we're not just going to let you run amok in our facility. You want to go look at some other equipment that's not on the complaint. I want to sit down and talk about why you think you've got a probable cause to do that, and maybe get on the phone with your area director. Meanwhile, no question, an hour later, that thing better be in adjustment.
Mm-hmm.
Somebody's back there making sure that it is. That doesn't mean we can't be cited for it, but it's going to make his job a lot harder to find out what the dimensions were while we were in the conference room talking about it.
Mm-hmm. If you can fix those things, I always appreciated that as a compliance officer. So we would be walking through the facility and we would see things that, hey, look, man, that cord's, in pretty bad condition, maybe we shouldn't be using that cord. And the employer, obviously without admitting any guilt or any wrongdoing, well, we'll get that taken care of right away, Doug. Thank you. As Eric mentioned, things that I can typically use some discretion on and not cite, if you don't do anything about it, or it's still there when I come back, we've had our extended opening conference and I come back and it's still there, I'm going to be disappointed. And there's a higher likelihood that I'm going to issue a citation for something like that. So if they're easily fixed, they're easily addressed, without admitting to anything, you can correct those. The compliance officers typically appreciate that and oftentimes won't address those in the citation package. Yes, sir, go ahead.
As a compliance officer, how do you feel if in this scenario you walked out to the bandsaw and it had been locked and tagged out that morning for service?
Oh, interesting. We hadn't had our opening conference yet. It was under service at that point before we had our opening conference. Well, Eric's suggestions are right on the money. And I only met Eric last night, so I have no obligation to,
Nice to meet
but
you.
he is right on the money, okay? I even read his blogs, frankly, and they're excellent. And so,
You and my mom.
right, the two of us. Yep, and yeah. But his recommendations are, if we're doing the opening conference and you are not out there walking through your shop, I am going to be disappointed in you. That is an opportunity for you to make a pass through there. You're not going to be able to correct any systemic deficiencies in your programs, but you can certainly tidy up the place and let everybody know. I remember going into facilities and approaching employees and they say, oh, we knew you were here. And I'm thinking, well, I didn't give advance notice, but I just sat in a conference room for an hour or an hour and a half while we were discussing and preparing. And they went through the facility and took care of those things. And so we do the opening conference and you're handed the complaint. Now you know what the items are and you have some I've got to make a few phone calls or you go out there and lock it out. Or if it was even locked out before I got there, again, if it's a violation and I can establish that employees had exposure to that prior to my arrival through interviews and any other means I might have, it's still a citable issue. I could still issue a citation for it, but the fact of the matter is, if you had not recognized that as a hazard and now it could be based on my presence, I think it's great that you've addressed it. You've tried to, okay, we didn't realize it was unguarded or it was in this condition. Thank you for bringing that to our attention, and we don't want it to get hurt, so we've locked it out for maintenance, for service. Some employers, to be quite honest, they try to be a little bit misleading. You've heard of the cases where a guy falls off a roof, then they put up the fall protection. That doesn't go well, after an accident like that. Throw the guards on it after somebody cuts a finger off. But, if you catch it while you're walking through while I'm in the conference room and you try to address it, I don't take exception to that. I think that's all right. Would you recommend against doing those things, or?
No,
Would you encourage them to?
Right. I think the key is you don't want to admit to any sort of violation, but take whatever actions are appropriate from a safety standpoint, and perhaps which might make OSHA's job harder. It's not your job to make their job easier. You're not doing their job for them. So if you're correcting something, they've got to ask the right questions. We're never going to lie. We're never going to mislead. If he asks, I see there's a guard on this bandsaw. The complaint says it wasn't there. Did you just put the guard on this morning, or did you put the guard on after I arrived? I'm not going to lie and say no, but if there's a guard on when he walks out there and he doesn't ask the right question and reaches the wrong conclusion, hey, that's fine. The key is there's a guard in place, it's safer, and he didn't ask the right question. That's okay.
Absolutely. Yeah. Yes, sir. Go ahead.
What about shutting down operations and sending people home?
So, are you from a company in Nebraska?
I was asked this question myself in a safety training we had a couple weeks ago, and I'm just trying to. My reaction was, it's dangerous.
I would agree. There's a case ongoing in Nebraska right now, a situation just like that, which is why I asked if you were. And it is. It's already been criminally referred to the Department of Justice because the employer was intentionally trying to mislead OSHA by shutting down a facility, locking it up, and trying to suggest that no work had occurred in that, where actually it had. So that was but in the construction world, let me just give you, when I would show up on a construction site, it's like flipping on a light in an old apartment where I used to live. The cockroaches just, you know, I mean, literally there would be nobody on site in 5 minutes. I've never seen a more orchestrated evacuation. And I left New Orleans before the hurricane, right? I mean, I've seen evacuations, but when the OSHA guy shows up on a construction, or used to be when they showed up on a construction site, they all left. They'd leave their tools, they'd leave. Hundreds of guys. It was unbelievable. You could, you know, and as far as OSHA's concerned, I just come back later. I mean, eventually you've got to come back to work and get your tools or whatever. So, you know, I would say that's kind of a, I'm going to be a little careful with that, but if you're walking me out to observe those violations in the maintenance shop, and I have to pass by an area where you would typically be working, it may not be a horrible thing not to be working there when I walk by, you know? I mean, just so this whole plain view thing, we don't want to push the limits of plain view. So if I'm walking out to the maintenance shop and everybody's taking a break, okay.
Yeah, I mean, so there's a big difference there, right? The example of suggesting to OSHA that no work goes on in this place, or we have stopped work for the day because of the OSHA inspection. You know, obviously, you never mislead, you never lie, you never falsify something. But I have more than a few occasions said, look, you know, your presence here, OSHA, is a distraction. I'm concerned that my employees will not work safely while you're doing this inspection. So they're here if you want to talk to anybody. But, you know, while you're interviewing people, we've got to stop production because we don't have somebody to backfill that role. Those are all appropriate responses to an inspection. They would not, you know, as long as you're not suggesting to OSHA that we don't weld, we don't have people operate this equipment, we don't do that, if in fact you do, you can say, we've stopped production because, you know, John, who ordinarily operates this machine, is getting your documents. Bill, who operates that machine, is about to be interviewed by you. It's okay to stop production temporarily for those reasons. Now, if OSHA says, I want to see something, right? I want to see a rail loadout occur, and none is scheduled to happen, it's perfectly fine to say, we're not loading any trains today, but he's going to say, I want you to tell me the next time you're going to be loading a train, and he can, by warrant or subpoena, I think it's really a warrant situation, can sort of require you to allow him to attend and observe that activity. So you can't sort of forever suspend operation, but I think it's appropriate to suspend it during that inspection activity unless or until he asks to see something. Mm-hmm. And then, as Doug says, I'm not going to create work just to show him, but you might be able to say, we've got a bin entry scheduled for either Wednesday or Thursday of next week, depending on, you know, how things go, how the bin empties on its own, and we'll give you 48 hours or 24 hours advance notice, and if you want to come watch, you can come watch. But it would be okay, I think, to stop the bin entry while he's there that day, because those guys are going to have to participate in the inspection. I think that's appropriate. But I'm not going to suggest that we weren't in the middle of a bin entry when he got there either.
Mm-hmm. I would agree, absolutely. I did have an occasion one time I was doing noise monitoring at a tube mill, and at about probably 2 in the afternoon, all the employees started coming up to me and handing me their dosimeters saying, God, I wish you guys would come every day. This is the earliest we've gotten off in 2 years. And I'm thinking, what? You know, I mean, they just suspended that, 4 hours early, they cut their day short, so my monitoring time was significantly less, which I thought, again, clever, It was always kind of a cat and mouse type of an arrangement, but I'm going to let Eric give you some practitioner's tips on these inspections. And
yeah, I'll do that very quickly so we can get to interviews. I know we've got about 8 minutes left or 9 minutes left, so I want to make sure we get to interviews. But there are practitioner's tips on walk-around inspections. Just a couple real quickly. Doug talked about taking side-by-side photographs, very important. To me, there's a real opportunity during this stage of the inspection to gather a lot of intelligence. What is OSHA thinking? Where are they going with this inspection? So one of the things that I love to do, and it has amazed me how successful this has been, is that while the compliance officer is taking a picture of something, I ask, or I have a company representative ask, what are you taking a picture of and why? He doesn't have to answer the question, but they almost always do. I think there's a problem with the guarding here. I think there's an issue with usually it's a guarding issue, whatever it is. It may not be obvious to us why he stopped to take a picture of this thing, but he tells us, then that we can either respond and explain why it's not a violation, why he misunderstands how the machine works or something like that, or we get an opportunity to do a quick fix without admitting that there was anything wrong with it, but you get some good faith and you get an opportunity there. So ask lots of questions. I do that too when he's writing notes. Hey, my boss told me to take good notes. What are you writing down and why? He doesn't answer that as often, but sometimes he does. He says, oh, well, I think I observed an issue here. This is what I think the issue is. It's a great way to gather intelligence. So ask lots of questions during those walk-around activities. The rest of it, I think Doug covered pretty well, and I know we want to get to interviews. This is generally the topic of OSHA inspections that I get asked the most questions about. During the opening conference, throughout the inspection, whenever, I like to lay down that ground rule that we want to coordinate these interviews in advance. If you want to talk to one of our operators, just let us know. We'll find somebody to backfill his position and bring him up to the conference room for an interview. I try to avoid as much as possible the stop and talk interview. OSHA walks up to an employee operating the leg and starts asking him questions about how he does his job. They're entitled to do that a little bit, but once it gets past 3, 4, 5 minutes, I generally will step in and say, look, I get you want to talk to John. He's doing his job right now. Can we let John finish doing what he's doing and bring him up to the conference room for an interview? Because I think this is disruptive. I think he needs to focus on both the things you're asking him to do, and he's not able to do that right now. So I try to put a limit to these stop and talk interviews to around 4 or 5 minutes. And then for anybody who's a supervisory employee, I don't want any stop and talk interviews at all. And the main thing to understand about supervisory interviews, and I guess that's a couple slides later, is that a supervisor's knowledge is imputed to the company. And I'm using the word supervisor here deliberately, not manager, supervisor. Anybody whose role it is to supervise the work activities of another, even if he's an hourly employee, even if he's the third most junior guy at the site, if he's supervising the activity of another, OSHA will consider that person to be a supervisor, and their knowledge and their statements are imputed to the company. So if he says, yeah, I knew the guard was off, but we had to get the work done, so we're going to get it done and then fix the guard later, well, the company has just admitted to a guarding violation and maybe set itself up not only for a violation, but maybe a willful violation. So anything that a supervisor says is really, really important. So I don't like for there to be any distraction. I don't like there to be any stop and talk interview with a supervisor, A, because I haven't had a chance to prepare that witness for the interview, and he's not focused. So I want to put a stop to anything like that with a supervisory employee. Just like we talked about for the opening conference, think about where you want your interviews to take place. Pick the right place and make it a sanitized area, home turf so the witness is comfortable and ready to go. I just talked very quickly about a couple things between hourly employee, non-supervisory employee interviews, and supervisory employee interviews. A non-supervisory employee has a right to a private interview with OSHA. Management representative will not be present for that interview if that's what the non-supervisory employee wants. The biggest fight, the most common fight that I have with OSHA during inspections is my participation or a manager's participation in interviews with employees. And OSHA has long mistakenly claimed that the right to the private interview is OSHA's right, and that is absolutely false. It is the employee's right. And if the employee desperately wants a management representative in that interview or wants the company's attorney in that interview, it is his right to ask for that, and OSHA has to, they have to abide. They can say, and this happens all the time, where they say, we will not proceed with this interview if you are going to participate, company lawyer. And I say, well, that's fine, and we're not going to have the interview. And they say, well, I'm going to go get a subpoena. And I say, well, that's fine. The law is crystal clear that if you have a subpoena for an agency interview, the witness can have any representative he wants to participate with him. So we can proceed today with me in the room, or you can get a subpoena, and we can do that later with me in the room. So it's up to you. I try not to have that fight if I don't absolutely have to, because this is one of those like demanding the warrant, where I feel like you're going to get some retaliation from the inspector if you do it. But there are certain circumstances where it's important, A, if it's really important to the employee, or B, you're in a situation like a fatality inspection where the circumstances, where the consequences are much higher, it's worth having that fight. So the other side of that is for supervisory employees, the company has a right to be present and participate in those interviews, and they should. And I think we ought to, if we're going to do an exercise, let's go ahead and jump right into that, because we'll run out of time otherwise. So you want to lead us through that, Doug?
Do you want to do a management interview?
Why don't we do just like we had this morning? Are we out of time already? I think we've got 2 minutes.
Do you want to do questions for 2 minutes, or do you want to?
Yeah, why don't we not do the exercise and just talk through some strategies?
If you want to be interviewed, stick around afterwards, and we'll put you through an interview.
So why don't we just real quick cover the closing conference?
Absolutely, sure. At the conclusion of this activity, as you understand, you will be provided a closing conference where the compliance officer is going to inform you of any apparent violations that they've observed while on site. That may be immediately after the walk-around portion while they're on site, or it may be later from the office when they've had a chance to discuss some of their findings with their team leader and perhaps compile the case a little bit, do some research. It may, before they know that they have a violation, they may have to do some research on the standards or interps, things like that as well. And so you may not get your closing conference immediately. If you have a lengthy inspection, you may want to ask them to maybe summarize their findings each afternoon, perhaps, so that you have some idea what it is they're focusing on or what they're observing. If it's just a one-day inspection and they're going to be done, conclude at the end of the day or sooner, you may not hear from them for a while. And frankly, unfortunately, depending on their workload, you may not hear from them for a while. Some of you have had inspections perhaps, and 3-4 months later, you still haven't heard anything. Now, that is incredibly frustrating. You're not really compelled to fix anything unless you receive a citation, frankly, although if it's obvious to you that it needs to be addressed, I would encourage you to do that. But with the 6-month statute of limitations, either from the time of an incident or the time of the opening conference, sometimes they sit on those cases for quite a long time, and it's very frustrating. And you will call, and you'll ask, what's going on, and I haven't gotten to it yet. So that can be difficult. And so, but you are entitled to get a summary from the compliance officer or his team leader at the conclusion of that inspection. And that's a great
Orchestra is playing, I think.
that is a great opportunity to ask questions, okay, in that closing conference. Take all of the opportunities you can to get clarification and ask questions during the procedure.
I know I'm planning to hang around for a little while longer today, so if you have any questions or anything, don't hesitate to ask.
Sure.
Our contact information is up here. I love talking about this stuff, would love to hear from you all. Your experiences out there. If you have questions, please don't ever hesitate to contact us.
Well, let's give a big round of applause for Eric and Doug.